What is this? Are you recording?
You want me to take it out?
Please.
The recording, yes.
Okay.
I didn't see that part.
Stop right here. This single moment sets the entire tone of the hearing. A judge asking, "Are you recording?" is never casual. Courtrooms are controlled environments. Recording without permission can violate court rules, privacy laws, and even criminal statutes depending on jurisdiction. And notice something subtle. The judge doesn't accuse. He probes. That's intentional. Judges often give people a chance to correct themselves before consequences escalate. Here's the bigger question for you watching. If someone starts a hearing by possibly breaking courtroom rules, how does that affect their credibility for everything that follows?
Right. Good morning, Ms. Ibas-Healy.
Hi, good evening.
So you're telling me that you have a lawyer.
Yeah,
Who is your lawyer?
Attorney Rehan.
Who is it?
Rehan?
See if they filed it. Do you know if this person is going to show up today?
Yeah, he's there.
Okay. We're just going to do probable cause now. You now are charged with unlawful restraint.
This is a crucial legal moment that many people misunderstand. This is not a trial. This is a probable cause hearing. The judge is not deciding guilt or innocence, only whether enough evidence exists to keep the case alive. Think of it as a legal checkpoint. But don't let the lower standard fool you. Even at this stage, the consequences are real. Up to a year in jail and a $4,000 fine. That's pressure. And when someone is warned of their rights this early, it signals the court believes criminal exposure is very real.
You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you. We will do this now. And then after that, we will just have you wait right over there for your lawyer to come. Hopefully they will show up. Okay.
Thank
Hi,
you,
Logan.
Your Honor.
Good morning.
On August 5th, 2024, officers were dispatched to a hostage event at a townhouse in Harris County, Texas. The reporting, who is the project manager of the townhouse.
This is where the case pivots. Unlawful restraint doesn't require ropes, cuffs, or a locked room. The law focuses on restriction of movement. A locked gate with no accessible key. That matters. No electricity, no air conditioning, limited exits. These environmental factors stack up legally. Even intent can be inferred from actions, not words. Ask yourself this. If someone can't leave without your permission, does it matter whether you say the words, "You're free to go"?
Townhouse complex called 911. The reporting indicated that the defendant was wearing an all-black religious garment and had a face mask. She had locked one of his employees, the complaining witness, inside a townhouse against his will. The reporting advised that the defendant was trying to evict a witness, or trying to get a witness to self-evict. She was trying to get the witness, who was her tenant in the townhouse, to self-evict by shutting down the power and water to the unit repeatedly. The complaining witness, who was the maintenance man for the townhouse complex, went to go check on the tenants to see if they were okay. The reportee indicated that the defendant locked the steel gate, which would not allow the complaining witness to leave. They had a key lock on the front and key lock on the back side. The tenant did not have the key to the back side of it, so if she locks the front, there's no way to pass through the gate.
Okay. So the unlawful restraint is
Yes, Your Honor.
outside?
It's a gate, and then it has, like the gate in the porch, on the porch, like a burglar gate.
Okay, so I'm assuming, so here's the door, and then you have, I guess what, like those black burglar bars that they
Yes,
say.
Your Honor.
Watch the judge carefully here. This isn't confusion, it's evaluation. Judges test stories by pressing on logistics. How did he get out? When? And why now? Inconsistent timelines weaken cases fast. And when a judge openly says something is unusual, that's courtroom language for this doesn't quite add up. At probable cause, ambiguity usually favors the state, but too much ambiguity can fracture the narrative.
So he couldn't get into the house?
He couldn't get out of the house.
And he couldn't
She
get
locked
out.
him in the house without electricity or air conditioning.
And no back door to get out? No window? I don't understand.
We're getting there, Your Honor. When officers arrived, they spoke with the complaining witness, who said that he escaped 5 minutes prior, and the defendant and the witness were still inside the home. The complaining witness reported the house was really hot because the air conditioning wasn't on. Complaining witness stated the back patio door was also locked, and the defendant had locked him in. Defendant had made a motion at the time to her purse, which the complaining witness believed, or which made the complaining witness believe that she had a gun. The witness corroborated the complaining witness's story. And
I don't understand how this person cannot just unlock the door and leave from,
it was locked. It's so the doors, instead of having a push button on one end and then a key lock on both sides, on the other side, it's a key lock on both sides.
on both sides.
That's the doors, Your Honor, which the maintenance man, the complaining witness indicated was a violation of the fire code.
But that's neither here nor there, but doesn't this person have a master key? Or I guess this is a residence,
He
right?
doesn't have a master key, Your Honor. He's the maintenance man for like the condo association. So he maintains the condo. Each of the units has its own keys.
How long was allegedly stuck in the house and how did he get out? This is unusual. And why? Was there did this, well, I guess,
He was attempting to turn the power and water back on in the unit because she has been repeatedly turning off the power from the tenants who live there. He told her repeatedly that he wanted to leave.
so presumably she's outside at this time?
She's in there with him, Your Honor. She asked him to sit down on a chair. There's a video that shows complainant asking defendant to let him go multiple times, and with her telling the complainant to shut up. I don't have the means by which he had left the apartment, Your Honor. I just know that he got out at some point.
This may be the smartest move in the entire hearing. The defendant does not speak, and that's powerful. People often think silence looks bad. In reality, silence protects you. Anything said here becomes evidence later. Judges respect defendants who assert rights correctly. And notice, the judge doesn't punish her for staying silent. That's how the system is supposed to work. Let me ask you this. How many cases do you think fall apart because someone talks too much too early?
In fact, he got out 5 minutes before the officers arrived.
So he was able to leave 5 minutes before the officers arrived?
Yes, Your Honor.
Did she let him go?
So it says, for the OR, at least the duration of time, I know that was asked was an hour and 20 minutes. I'm gonna see how he left. I'm trying to read through the OR to supplement your questions, Judge.
I don't know if I'm ready to rule yet. Ms. Agbacieli, are you sure that you're going to have a lawyer here today? Because I'd like to hear your side.
My lawyer, yeah.
Um,
Attorney Rehan, yeah.
I don't want to rule just yet, but I'd like to hear your side. If there's,
I'd like to be silent. I'd like to wait on my lawyer.
well, right, I'm right. And I'm not asking you to say anything now. When that person gets here, then you talk with them and then we can
Yeah, sure.
readdress
Yes, sir.
PC at
Yes,
that.
Your Honor.
So do you mind just taking a seat for me and then just giving us a heads up when your lawyer comes? Come, Ms. Agbacieli, come up, ma'am.
I explained to her the no contact, yeah.
Okay, great. Okay,
Go ahead.
I am going to find that there's probable cause to go forward. If something develops in the future, I've told that you guys can come back and we can argue about probable cause. The only thing I'm going to ask you is please do not have contact with the complaining witness in this case and don't be in possession of any weapons. As long as you can abide by these and you do not pick up any new cases, you will be fine with us. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but please stay in contact. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant, okay? Do you have any questions? Okay, so just no contact, no weapons, and that's it, okay?
Thank you, Judge. Thank you.
Okay, thanks.
Just to go back to the body cam issue itself, right?
This is the balancing act of the justice system. Probable cause is found, but with conditions. No contact. No weapons. Stay clean. Translation: the court is watching. One misstep and the situation escalates fast. The judge even leaves the door open to revisit everything. That's rare and telling. This case isn't over, it's paused. So here's the real question for you. Based on what you heard, was this unlawful restraint or a landlord-tenant dispute that crossed a dangerous legal line?